question here today is, did the state of Kansas carry the burden to show probable cause that the defendant's use of force was not statutorily justified? The argument the state makes is, in part at least, the effort to hide the knife, but and this is just a probable cause hearing, like the state says. But even at a probable cause hearing, if you're trying to hide evidence, the last thing you do would be either call 911 or or Mr. Hill's mother, and that's what she did. Who knows where things fall after a stabbing, or if she put it in the trash or put it in the sink. And where the blood is, I didn't see anything that helps the state at all. The evidence I've heard today clearly shows that Mr. Hill has a reputation for violence even amongst his family, and in their opinion, he's violent. And to some extent, even when they try to hedge on that, other incidents of specific instances of conduct came in to impeach the testimony, and it just shows that he has beaten his girlfriend, the defendant in this case, savagely on several occasions. He's beaten his own mother. He's beaten his own grandma. Again, they hedge on that. All three of those folks are enablers. The defendant's an enabler, the mother's an enabler, the grandmother's an enabler. And so nothing ever came to the court. I think that's clear from the evidence. If so, I think Mr. Haney would have put that into evidence. But something did come to the court in Wichita, and that's, of course, one way to show the defendant's character for violence, domestic violence in this case. It shows the case law here says where self-defense is an issue, as in this case, in this homicide case, or in any homicide case, evidence of the turbulent character of the deceased is admissible. Such evidence may consist of general reputation, evidence that we've heard here today of the deceased, general reputation in the community, and specific instances of conduct may be shown by conviction of a crime, and then we have the 2013 convictions of domestic violence against that victim. The people that were very close across the street, the Stewarts, of course, were called by the mother. And of course, the mother, I believe it's true that, I mean, if you're just, why wouldn't you call the police at that point unless you were continuing this enabling behavior? You call Melissa Stewart to go calm it down and without getting your son sent to prison. I understand why people stand in the way of the right thing when they're protecting their own child. I get that. And so that's all that is. And then they get over there and find that he's in effect dying. We know now he's dying. So the question is, with all the beatings that all of these women have endured at the hands of him, and she of course was aware of all that. It sounded like the reputation that he had was there, and of course she knew firsthand how much stronger he was than her. She's a petite woman. I don't know. I won't guess the weight, but very light, looks like to me. And it's the strength difference between men and women. And if you don't really need to guess about it too much, because you can see the photos of the times that he has beaten her. He's broken her jaw twice. So the question is, she testified she was trying to save the life of about her her subjective state of mind. Did she feel it was the use of force was necessary? She testified to that, and so that's clear. So that's the first prong that she has to cross. But the the prong for me to judge right now. You know, first of all, I checked that box. She's checked that box. Said so repeatedly to people in interviews. Nothing very inconsistent about it at all. I don't know how soon you have to say it when the police arrive, but I'm not sure she's even sure what she did, her testimony, but she did believe she had saved the life of her child. So the question then becomes whether or not the use of force was objectively reasonable. And of course it was. There really isn't any question about that. From the evidence that I see here today, it was objectively reasonable. It would have been, to me, objectively unreasonable not to have done something. The only evidence I've heard is that he was in that vortex of violence that night that he'd been in, you know, for a good portion of his life. And that that unfortunately now Ms. Pearson had to do something she obviously didn't want to do. She wasn't prepared to do it, and broke down afterwards, started calling the mom to get 911 called and all of that. She wasn't trying to hide anything, she just collapsed. So long story short, I'll write an opinion about this. It'll be, you know, probably better than what I'm announcing here, but this is a pretty easy one for me. That the defense's motion for immunity is granted and the case is dismissed. You are free to go. This hearing's concluded.
So at the end of the day, the judge decided that the use of force in this case was objectively reasonable. And as I said while he was reciting it, I said, this kid's background is what did him in. The idea that making it objectively reasonable was because he said he had been in that vortex before, and his history of violence all makes it reasonable.
Yeah, and the specific incidents with her that broke her jaw twice. I mean, to recite all of that, clearly she felt force was necessary, and he did find it was very reasonable. All right, I think we have a moment to bring in our guest here now to discuss criminal. Oh, let's watch this.
Thank you so much.
Good?
Yes.
It's over.
I know, thank God, thank God.
Over much. No idea. Okay. No, I would actually point out that my original charge of reckless murder.
We obviously wanted to bring that to you. There Ashley Pearson is. She's been fighting this battle. This happened back in 2018. Finally has a day on court on this motion, and it is now dismissed. The prior DA didn't choose to charge her, believed it was self-defense. Then there was a new DA who brought the charges.